Okay, we're already up to 2:20, so I think I'll start. Welcome everybody. Good morning, good afternoon, good evening, where it is in the world that you're joining us. You're very welcome to this virtual CPC webinar on international humanitarian law. I don't want to spend too much time on housekeeping. We've got quite a packed schedule, and none of you are joining to hear formalities or the housekeeping and the logistics. So I'll race through those, and I'll then pass over to our Secretary General, Mr. Stephen Twigg. Firstly, I should say that this webinar is being recorded. It's not being live streamed. So if any panelists or any attendees would like certain parts of this, or they feel uncomfortable at certain parts of this webinar being recorded, please do let us know, and we'll do the best to accommodate accordingly. You'll also note that we have a chat function on the webinar. I'm sure many people joining us are familiar with Zoom, but please do use that chat function. Notably, please do use it as part of the Q&A. We are hoping to take written questions rather than oral questions. So if you have any questions for our panelists for the latter part of this session, please do write it in there. Equally, if you'd just like to discuss other matters amongst yourselves, you're also more than welcome to do that. That's why that is there. The CPA does have a respect policy. No doubt that'll be adhered to and we won't have any issues, but we do always want to conduct these sessions in the most inclusive and supportive manner possible. Finally, just to say that this is one of a series of webinars that the CPA are delivering. Earlier this week, we had a session on climate change. We also have further sessions on social media, youth engagement, and inclusiveness of persons with disabilities in the legislative process. So we do welcome anyone who's registered for this to also register for those, and to get in touch with the Secretariat if they want more information about that. As I say, I don't want to spend too much time on the formalities and the housekeeping. So without further ado, I'll pass over to our Secretary General, Mr. Stephen Twigg, to begin the proceedings.
James, thank you very much indeed, and good morning, good afternoon and good evening to everyone who's joined us for this seminar today. Can I say I'm delighted that we're holding this webinar. It's a subject very close to my heart, and we have a truly fantastic lineup of panelists to hear from, after which we'll have an opportunity for question and answer. So I'm going to go straight to the first of our expert panelists. If I can welcome Calisiana Thin. Calisiana is the legal advisor at the International Committee of the Red Cross. She's going to speak to us about the development of international humanitarian law and the work of the ICRC. She comes with a wealth of experience over the past 17 years in this area and in international criminal law and broader international human rights law as well. Calisiana, over to you.
Thank you very much, Stephen, and thank you very much to the Commonwealth Parliamentary Association, both for holding this seminar on international humanitarian law and also for inviting me through the ICRC to speak. So I do only have 20 minutes, so I will endeavour to be as quick as possible, while also not rushing through it too much, so that everybody can understand. So I'm going to be talking about the history and development of international humanitarian law today. And I've put up a couple of confronting images here, just to start you to think about what is international humanitarian law all about. I mean, it's both about attacks on a hospital, attacks on civilians. It's the use of certain types of weapons, and it can even be regulating cyber attacks as well. So I'll turn in a moment to what international humanitarian law is really all about, but essentially to say that it is about regulating warfare. Unfortunately, the key aspect of IHL, international humanitarian law, is that it recognizes that conflicts exist. It doesn't seek to end them. It doesn't seek to create peace. It just recognizes that they're ongoing and they need to be regulated somehow. They need to, there is a need to ensure that the minimum amount of suffering of civilians and of soldiers takes place during conflict. So if we were to ask the question as to, are these violations of international humanitarian law, let's say an attack on an ambulance, the use of a landmine, a cyber attack, then we would have to ask a few questions about the facts on the ground. So we would ask, where are they taking place? Are they taking place in a country where there is already an ongoing conflict that we're aware of? Or are they taking place seemingly in times of peace? In what circumstances are they taking place? Who is involved? Is it a known non-state armed group that's operating? Is it a state that might be responsible? Who are the victims, indeed? And what were they doing at the time? So there are a number of questions that really go to the heart of the practicality of the situation. So international humanitarian law often requires these fundamental questions to be asked at the beginning in terms of what are the facts on the ground? And then that enables us to then apply the law to ensure that we recognize whether there have been violations of international humanitarian law. And why do you want to know whether there have been violations of international humanitarian law? Well, partly to ensure that those causing them might be able to be brought to justice. And as parliamentarians, you have a role to play in developing legislation to ensure that people can be prosecuted if they have been alleged to commit war crimes. But also so that your diplomatic or any other communication around this issue is accurate. There's no, it's not very good to say, oh, this was a violation of international humanitarian law, when in fact it was a time of peace. Or indeed, it might have been a legitimate attack under the rules of international humanitarian law. So it's important to know international humanitarian law to be able to respond appropriately. Other steps that you might want to take would be to limit arms sales, to call on a state or a non-state armed group to stop their actions, to ensure that your own military engagement is appropriate. Do your armed forces need more training? Do other armed forces around the world need more training? What sort of support can your state give to other countries to limit the violations of international humanitarian law? There might also be the possibility for UN or other sanctions. So it's important to understand what is international humanitarian law. And in that regard, it is a branch of public international law. So it is established by customary law or treaty. And I'll turn in a moment to what customary law is, and also a range of treaties for international humanitarian law. And the important thing to note is that it's generally applicable in times of armed conflict. There are certain provisions of international humanitarian law which require preparation in times of peace. So being prepared for receiving prisoners of war, putting in place the relevant legislation, training of armed forces, and so on. Many of these things need to have been put in place before there's an armed conflict. But generally, it limits the amount of suffering that goes on in times of armed conflict. So there are two main reasons for being for international humanitarian law, and those are those on the screen right now. So it protects persons who are not or no longer participating in the hostilities, and it also protects places and objects. So often when we think about the protected persons, we think about civilians. But civilians are not the only people who are protected in times of armed conflict. So anyone who has been detained is also protected by international humanitarian law. And this is whether they are civilian, criminal detainees, or security detainees, or soldiers who have been detained, and particularly prisoners of war in international armed conflict. Also, soldiers who have been wounded or are sick or shipwrecked are also protected persons under international humanitarian law. And international humanitarian law restricts the rights of the warring parties to use the means and methods of warfare that they choose. So essentially, it limits the use of certain types of weapons, and also how those weapons are actually used. So now I'm going to turn to the history of international humanitarian law. And Indeed, it's not just the last 150 years that we've been talking about rules that limit the effects of armed conflict. In fact, for thousands of years, we've had examples through religious texts, through traditions and stories of regulating the way that soldiers, the way that people who are engaged in armed conflict conduct themselves. So, for example, ICRC is collecting a number of different traditional warfare practices, such as this one from the Pacific Islands, mostly from Melanesian countries, in terms of the traditional warfare practices that took place in those countries well before colonization. In the next few weeks, we're also launching traditional warfare practices that we've collected from Southern Africa. We also have a range of different projects dealing with how international humanitarian law is reflected in Islamic legal tradition and in Buddhist legal tradition. So really, international humanitarian law in various forms has been around for centuries. But what we would call modern international humanitarian law originated from the ideas of Henri Dunant, who was from Geneva. He was actually a businessman. He traveled to meet Napoleon about some business dealings, and he came across this battle in Italy. And it was a terrible battle. 10,000 people were injured and died in one day over this battle. And Henri Dunant was horrified by this. He and a number of villagers from the surrounding villages collected the wounded and sick and dying and enabled them to write letters home to their families. They provided them with first aid. And Henri Dunant said that there should be relief societies created to be prepared in times of peace for warfare. And these have now eventuated into National Red Cross and Red Crescent societies, which each of you have in your own countries. And also an international treaty should be created to protect the wounded and sick on the battlefield. And this idea led to the very first Geneva Convention of 1864. Basically, it protected soldiers who were wounded during combat. An interesting statistic is that at the Battle of Solferino, there was one civilian who died. Nowadays, of course, unfortunately, we see that 90% of the casualties of war are civilians. So I'll come on to that in a moment as to how we better protect civilians. But essentially at this time, it was soldiers and medical facilities that really needed the protection. And the very first Geneva Convention, the very first conference, decided to take the Swiss flag, because the conference took place in Switzerland, and inverse it to create the Red Cross emblem as a sign of the identification of the military services, so that they would have a symbol of protection. And that's how we got the very first Red Cross. The Red Crescent then came a little bit later. It was initially used towards the end of the 19th century by the Ottoman Empire as a symbol of protection, and it was recognized formally in 1929. So there were a number of issues with the very first Geneva Convention. It was very short. It was very much limited to soldiers and medical facilities. Then, of course, came about the era of naval warfare, and so additional treaties were created around naval warfare. Additional treaties were created around different types of weapons that could be used. And in 1929, at the end of the First World War, it was recognized that they needed to have some laws around the treatment of prisoners of war. So even before, in fact, the very first Geneva Convention, we had the Lieber Code, which was during the American Civil War. And then very shortly afterwards, there was a Declaration of St. Petersburg, which was a European-wide gathering to put in place several fundamental principles of limitations on human suffering during times of armed conflict. And then the Hague Conventions in 1899 and 1907 put in place concepts of neutrality and also limitations on certain types of weapons and means of using those weapons. And then came the Second World War, and it was recognized that really, because of this mismatch of a whole lot of different laws, we really needed to have something that was much more substantive, drawing together a range of different principles to protect more people, including, and in particular, further protections on prisoners of war, and also of civilian persons. So in 1949, 4 Geneva Conventions were adopted. So on wounded and sick on land, wounded and sick and shipwrecked at sea, prisoners of war, and the protection of civilian persons. However, while the Geneva Conventions are really the fundamental treaties nowadays in relation to international humanitarian law, they all dealt with the protection of persons and medical transportation and so on, but really around the protection of persons. There wasn't a lot that drew on the existing customary law principles of how to engage in armed conflict, how to launch attacks in order to limit suffering, which we call the principles of the conduct of hostilities. So in 1977, there were 2 additional protocols that were adopted. One on international armed conflicts, which really brought together a range of these principles relating to conduct of hostilities, principles such as distinguishing between combatants and civilians, the principle of proportionality, and the principle of precautions in attack, for example. Also, since the Second World War, we'd seen a range of conflicts that were not international armed conflicts anymore, much more non-international armed conflicts taking place in one state. And so Additional Protocol 2 regulates non-international armed conflicts, which are conducted in the territory of one state, where the non-state armed group has significant control over territory. And then we do have one final additional protocol, which is from 2005, which adopts a new distinctive protective emblem. So as you can see on the screen, it's the red crystal. So it joins the Red Cross and the Red Crescent as an additional protective emblem for those countries that do not wish to use either a cross or a crescent. So, of course, as I said, the Geneva Conventions and their additional protocols are really the fundamental treaties nowadays that we refer to in terms of international humanitarian law. But there are a range of other treaties which also impact on international humanitarian law and create international humanitarian law. A number of them are regulations, rules prohibiting certain types of weapons. There are some treaties, such as the protocols to the Conventional Weapons Convention, which limit the types of weapons that can be used or restrict their use to certain circumstances. There's also a number of human rights treaties which impact on international humanitarian law, and one of those on the screen there is the optional protocol on the involvement of children in armed conflict. That's the optional protocol to the Convention on the Rights of the Child. We also had protection of cultural property with the Hague Convention in 1954, and then its optional protocol in 1999, which put in place special protections and enhanced protections for cultural property. And the most recent one, of course, is the Treaty on the Prohibition of Nuclear Weapons, which a number of Commonwealth countries have now become a party to, and it actually entered into force just exactly 1 month ago. I also have up on the slide the Statute of the International Criminal Court and the Arms Trade Treaty. So the Statute of the International Criminal Court is not a treaty relating to international humanitarian law as such, but it does codify a number of war crimes coming out of the Geneva Conventions and the additional protocols. And similarly, the Arms Trade Treaty is not an international humanitarian law treaty, but it does require an assessment made by each country that's a party to it as to whether the weapons that are traded are likely to cause humanitarian law violations. I mentioned very briefly customary international humanitarian law. Basically, under international law, this is law which states follow, even though it's not codified necessarily, that they consider to be rules that they should follow. And we derive it from evidence of state practice and also what states say. The Latin term is opinio juris. And in 1995, ICRC, the International Committee of the Red Cross, was commissioned to identify a number of these customary international humanitarian law rules. And so over a process of 10 years, my colleagues identified 161 rules which apply predominantly in both international armed conflicts and non-international armed conflicts. Those that are only applicable in international armed conflicts primarily relate to principles that apply during occupation, which is considered to be international armed conflict. And so those 161 rules are on the International Committee of the Red Cross website. And we're constantly updating the practice that is associated with those 161 rules. And that practice is also on our website. Just very briefly, what role does the ICRC play in relation to international humanitarian law? Well, the mission statement of ICRC is up on the screen. And obviously, the main role is as a humanitarian organization to protect victims of war and provide them with assistance. But we also endeavor to prevent suffering by promoting and strengthening international humanitarian law, as well as universal humanitarian principles. That's the last point there on the slide. And in fact, international humanitarian law really cuts across everything that we do in terms of protection. So by protection, we mean ensuring the protection of those who have been detained, ensuring the protection of civilians. Anytime we make an intervention to a military or to a non-state armed group about how people have been detained or whether there have been attacks on civilians, then we're doing this within an international humanitarian law framework. Similarly, in relation to assistance, we provide water, we provide food packages, we provide vaccinations for people, for livestock. We provide economic assistance, but we do this within the framework of international humanitarian law through the access that is granted to impartial humanitarian organizations through the Geneva Conventions. In relation to prevention, obviously that's pretty much self-explanatory, that we aim to do a lot of work in relation to prevention of violations of international humanitarian law. And prevent, yes, basically essentially preventing violations from occurring by ensuring that the legal framework and the understanding of the legal framework is in place before times of armed conflict. And then we also engage, of course, we cooperate a lot with the National Red Cross and Red Crescent societies around the world, both in terms of dissemination of international humanitarian law, but also in terms of strengthening the legal framework in each country, as well as, of course, the ongoing protection and assistance work that we do with National Red Cross and Red Crescent societies. What role can parliamentarians play? Well, a range of different things, and in fact, it's the last point on the slide. But I would suggest that you look into the role that the Interparliamentary Union's Committee on the Promotion and Respect for International Humanitarian Law does. They do a lot of work with parliamentarians on understanding what international humanitarian law is all about, and on supporting the creation of legal frameworks in each country around international humanitarian law. Recently, they've done quite a lot of work around the Treaty on the Prohibition of Nuclear Weapons. So a range of parliamentarians have been very active in that regard. They're also very interested in the Arms Trade Treaty and particularly the humanitarian law side of the Arms Trade Treaty. And similarly, of course, the Commonwealth Parliamentary Association and the British Red Cross have launched a handbook for parliamentarians on international humanitarian law, as has also the Interparliamentary Union. And I think that both handbooks are very complementary to each other. And then, of course, the obvious thing that parliamentarians can do is support the passage of legislation to implement international humanitarian law. But also, going back to my very first slide and my points then, making sure that you're aware of the latest developments of international humanitarian law so that you're able to make the right decisions in relation to communication about situations around the world and also how to respond to those situations. And finally, just supporting dissemination of international humanitarian law within your own country so that everyone is aware of those rules that limit the suffering of people during times of armed conflict. Thank you very much.
Calisiana, thank you very much indeed. That was a superb oversight, very comprehensive, and really aids our debate today. And I think many striking things from what you've said, but that figure that in current conflicts around 90% of the casualties of war are civilians is a very instructive statistic. And I'm delighted that we have the handbook that the CPA and the British Red Cross have developed, and we're working on an updated version of that handbook to be published at some stage later this year. So thank you, Calisiana. Let me now turn to the second of our expert panelists. I'm very pleased that we have with us Professor Colonel Charles Garraway from the International Institute of Humanitarian Law. He comes with an extraordinary story of commitment here, 30 years career as a legal officer in the British Army, followed by, I think, almost 20 years in a wide range of roles. I won't list them all, there are so many that relate to international humanitarian law, but if I can pick out one, because it's a country that I've taken a close interest in, he served for 2 years on the group of eminent experts on Yemen, a tragic case study of what happens when international humanitarian law is threatened. So, Charles, I'm delighted that you're with us, and I'm pleased to invite you to speak next.
Thank you very much. I'll just see if I can get my slides up. There we are. Right. I will be following Calisiana, and I'm very grateful for the opportunity to do this. There will be a degree of overlap, but what I'm going to try and do is try and show the framework under which all the treaties grow, so that you can see that, in fact, this is not something that has just been plucked out of the air. It is something that is built on lengthy and deep foundations. Whole degree courses are done on this, so I'm going to try and do it in 20 minutes or less and see how I get on. The laws of war are as old as the hills, as we've heard, but have always been the subject of cynicism. Look at Cicero. I didn't put it in Latin, you'll be pleased to hear, despite having had the same Latin teacher as our Prime Minister. I'm a little bit older than he is, I might add. Even in more modern times, you see the great German military theorist Clausewitz had little time for the law. However, I would say the cynical view was wrong. It was wrong then, and it is wrong now. There have always been laws of war. Sun Tzu refers to them in China in the 1st century BC. They appear in every civilization and religion. They're found in the Bible and the Quran. They're in the Hindu Code of Manu, and as we have heard, in tribal traditions all over the world, from Pacific countries through to Africa. War was never without restriction. In more modern times in Europe, there were the codes of chivalry of the Middle Ages, and then the Articles of War, sets of regulations drawn up to govern a country's conduct in time of war with its military and naval forces. These are not a modern invention based solely on Western Judeo-Christian thought. They are universal. But even today, there is cynicism. The great international lawyer Hersch Lauterpacht, who played such a role at the Nuremberg Tribunal, comes up and says if international law is in some ways at the vanishing point of law, The law of war is perhaps even more conspicuously at the vanishing point of international law. But IHL, International Humanitarian Law, remains as relevant today as it was in the days of Sun Tzu. It is based on custom, developed down the ages, ancient custom. However, as you have heard, since the middle of the 19th century, it has become increasingly codified through a series of treaties dealing with the protection of victims, the conduct of hostilities, weapons, protection of the environment, and many other aspects of the art of war. The best known are obviously the four 1949 Geneva Conventions, which have universal ratification, and their additional protocols of 1977 and 2005. However, treaties can never cater for anything, for everything. And this was recognized by the great Russian diplomat, Fyodor Martens, who at the Hague peace conferences of 1899 and 1907, when much of the law on the conduct of hostilities was originally codified, came up with the famous Martens Clause. I've set it out here in its modern form, 1977. In cases not covered by this protocol or by other international agreements, civilians and combatants remain under the protection and authority of the principles of international law, derived from established custom, from the principles of humanity, and from the dictates of a public conscience. This, in effect, takes us back to the foundations of international humanitarian law. The treaties are based on those foundations, and it is to those foundations that I now wish to turn. The law, both in customary and treaty form, is based on a number of principles. These principles are sometimes known by different names in different parts of the world, and their content may be expressed in slightly different wording. Some have been codified in whole or in part in treaty. But whereas treaties only bind those states parties to them, these principles, as long established custom, bind everybody. They are universal. I have listed 5 and we'll look at them each in turn. Distinction, perhaps the key principle. It has been described by the International Court of Justice as one of the cardinal principles of international humanitarian law. I've chosen 2 forms of wording here, one from an ICRC British Red Cross fact sheet, and one from a state, the UK Manual on the Law of Armed Conflict. I've done this to show that there are different ways of expressing this. However, although they are slightly differently worded, the underlying principle is, I would submit, exactly the same. It is the application of the principle that is difficult, not the principle itself. In international armed conflicts between states, a clear distinction is drawn between combatants, a clearly defined category of people who have the right to engage in hostilities, and civilians, everybody else. The situation is much less clear in non-international armed conflicts, the majority of conflicts today, where there is no combatant status. It is therefore necessary to look for other criteria to decide who is protected from direct targeting and who is not. I have referred here to the concept of direct participation in hostilities, by which it is agreed in both treaty and customary law that civilians would lose protection. Who is a civilian for these purposes, and how the concept is interpreted, was the subject of extensive discussion and later guidance issued by the International Committee of the Red Cross in 2009. This guidance is not universally accepted. It is not law as such, but it is an excellent starting point for trying to apply the principle of distinction in these most complicated situations. As we have heard, all civilians are entitled to protection. so long as they do not take a direct part in hostilities. However, certain categories of people are entitled to special protection because of their extreme vulnerability. The nature of that protection is now mainly laid down in treaty form, particularly in the Geneva Conventions and their protocols. Distinction also covers objects. Various attempts to devise lists of what objects were targetable, military objectives, have fallen by the wayside down the years, and the term military objective is now defined in more general terms. Insofar as objects are concerned, military objectives are limited to those objects which by their nature, location, purpose, or use make an effective contribution to military action and whose total or partial destruction, capture, or neutralization in the circumstances ruling at the time offers a definite military advantage. It is a two-tier test, and this treaty text is subject to detailed interpretation on almost every word. For example, the meanings of nature, location, purpose, or use. Civilian object is anything that does not fall within the definition of a military objective. Civilian objects are protected. However, remember the key words in the definition of military objective in the circumstances ruling at the time. Objects can change from one category to the other, depending on the circumstances. Thus, a house is a civilian object. But if it is used as a gun emplacement, it may become a military objective. It may cease to be so, again, when the gun emplacement is moved. Just as with people, certain categories of objects may have special protection because of their particular role. Again, these are mainly defined in treaty, and I have laid some of them on the screen here. A number of emblems have been devised to indicate protected objects and people. The best known are, of course, the Red Cross and the Red Crescent, but they are not the only ones. The emblems themselves do not have protection. They're designed to indicate what is protected. Thus, sticking a Red Cross on a tank will not give that tank protection. It will, however, be a misuse of the Red Cross emblem and a war crime. It is because of the necessity of protecting the integrity of these emblems, particularly the Red Cross, Red Crescent, and Red Crystal, that their use is strictly regulated in times of peace as well as time of war. Principle of necessity. The military have a mission which they need to carry out, and this is recognized by the principle of necessity. It is open to argument whether this is a limiting principle or a permitting principle, and I'm not going to enter into that philosophical debate. However, the principle of necessity is not absolute. The laws of war take into account military necessity, and so this principle is no excuse for engaging in prohibited conduct. In certain cases, the law allows certain conduct, specifically in the case of military necessity, for example, destroying or seizing enemy property. But unless there is such a specific exemption stated in the law, military necessity is no justification for breaking the law. It was realized very early on in the treaty process that there is a conflict between the requirement to allow the military to conduct their mission and the needs of humanity. It is the balance between these two sometimes contradictory principles that lies across the whole of the law of armed conflict. Go too far towards military necessity, and you have barbarism. Too far towards humanity, and it becomes impossible to carry out military missions lawfully. But the principle of humanity is critical here. And it is the key part of this Faustian pact. Here you will note that the wording on the ICRC fact sheet and the UK manual is identical. War is not without limits. And here we move particularly to the use of weaponry. We find a clear statement that war is limited, and the text refers to the concept of unnecessary suffering. But unnecessary suffering inevitably means that in war, regrettably, there is necessary suffering, and that cannot be avoided by the very nature of warfare. However, the aim is to limit that suffering as much as is possible. It's easy to state that unnecessary suffering is prohibited, but how do you operationalize that? The way it has been done mainly is by a series of treaties prohibiting the types of weapon that the international community either considers to cross the boundary of unnecessary suffering or for other reasons believes should be removed from the inventory. First three on my list are banned by both treaty law and custom. The ban is thus universal, regardless of whether a state has ratified the relevant treaty. However, the last three are more complex. They are banned for those states who are parties to the relevant treaties, but not necessarily for those who are not. However, a treaty ban can become so universal that it turns into custom. Whether or at what point that will happen with these weapons remains to be seen, but many would say that that time is already close. Other weapons are restricted to specific situations and how they can be used. Some would argue that expanding bullets are already prohibited, but they can be used legally in domestic law situations, such as hostage taking. Even if not prohibited, the situations in which these weapons can be used are very limited. I will not go into the debate on nuclear weapons, as we've never been as. It is in the principle of proportionality that the Faustian Pact is most evident. It is recognized that as a result of legitimate military operations, there may be totally innocent lives lost and civilian damage caused. This upsets many, and is indeed difficult to square sometimes with human rights principles. But it is a recognition of the reality of war. It cannot be conducted, despite modern technology, without the risk of civilian casualties. This has become even more so with the increased urbanization of the battle space. It must be noticed that the balance here is between the expected losses and the anticipated military advantage. It is not an ex post facto judgment based on results. When looking at the proportionality principle, many overlook the principle of precautions. Merely to decide that civilian losses are proportionate, or in the words of the principle, not excessive, is insufficient. There is a further obligation to take all feasible steps to reduce civilian losses to a minimum. This may involve altering the timing of an attack, the direction of attack, or the type of weapon used. Can a warning be given? All these are factors that the planners have to take into account. Targeting is extremely complex, as anyone who has watched Helen Mirren in Eye in the Sky will appreciate. I move finally to state obligations, and I place this under three headings: educate, support, and prevent and punish. States have obligations in both treaty and custom to train their armed forces in international humanitarian law. This is vital. An undisciplined force is as much a danger to itself as it is to others. How this is done is left up to states, but there is much help available from bodies such as the ICRC. There is a need to incorporate IHL into military manuals and doctrinal publications so that it cascades down through the ranks. But we should not forget the civilian population. Apart from enabling them to understand their own rights in time of war, your reserves will be called up from the civilian population. It's too late to start training them then. The earlier they learn the basic rules of IHL, the better. There are aspects of IHL which require prior planning and support structures in place. It's too late to worry about prisoners of war when you catch them, as one famous general once said to me. There need to be detailed planning from the front line back to the government itself, including arrangements for documentation. This has to be done in advance. It didn't help me in 1991 when I asked to see the UK government prisoner of war forms before the Gulf War to find that they were in English and Spanish, left over from the Falklands War. Fortunately, the ICRC came to our rescue. Is there domestic legislation to implement IHL, and is it up to date? How will you deal with the disciplining of recalcitrant prisoners of war? National IHL committees, consisting of both relevant government departments and bodies such as the National Red Cross or Red Crescent Society, can help here in identifying areas where planning is necessary or legislation should be introduced or updated. We live in a global world, and states can help ensure respect for IHL by using their national influence, both formally in bodies such as the UN and informally through bilateral contacts. The Commonwealth has a role to play here. I was myself involved in the drafting of the model Commonwealth law for the implementation of the Rome Statute on the International Criminal Court. IHL appears frequently in discussions at high-level Commonwealth meetings. And of course, there is the joint CPA and British Red Cross IHL handbook for parliamentarians, of which you've already heard. Perhaps the most important part of legislation is in the enforcement field. When things go wrong, can you do anything about it? States are obliged by treaty to incorporate into their criminal legislation the power to investigate and prosecute grave breaches of the Geneva Conventions and, where applicable, Additional Protocol 1. States parties to the ICC statute would be well advised to have incorporated all the ICC crimes into their domestic law, so as to be able to take advantage of the complementarity principle on which that court operates. But IHL is primarily civil in nature, and there are other violations of IHL which do not amount to international crimes, or even crimes at all, but may still involve state responsibility for failure to comply. What action has been taken to suppress those through administrative or criminal procedures? I end with a reminder from Nuremberg. In all of this, whether we are talking about war crimes or the simple conduct of military operations, it is people we are talking about. Men and women, military and civilian. We owe it to them to take this seriously and to ensure that war, this most dangerous of activities, is carried out with the minimum of damage. We may not be able to abolish war, that's a separate subject, but we can, in the words of the St. Petersburg Declaration, seek to conciliate the necessities of war with the laws of humanity. Thank you.
Professor Garraway, thank you very much indeed. I think very, very thought-provoking contribution. And I think in particular, where you ended with those state obligations, noticing some of the questions that are already coming in, they're very much about what can be done moving forward in those areas of educate and support and action to prevent and protect. So thank you. We're going to move now to hear from the first of our parliamentarians in response. Can I encourage colleagues who are on the call to please do put in questions either in the Q&A function or the chat function. We already have a number of questions, which is very welcome. Can I now introduce Senator Marilou McPhedran, who has been a Canadian senator for Manitoba since 2016. She is a human rights lawyer, professor, and activist with a distinguished track record across the human rights sphere, but particularly with a focus on women's rights. I'm delighted, Senator, that you're able to join us, and the floor is yours. Thank you.
Thank you so much. Greetings from Canada to parliamentarians from across the Commonwealth, and a very warm note of appreciation to my co-panelists. I wish to acknowledge that the Parliament of Canada is situated on the unsurrendered territory of First Nations in our country. I also thank our moderator, Mr. Stephen Twigg. I think this is the first chance we have had to meet. It was a pleasure to prepare with you. And of course, the staff at the CPA headquarters, our Library of Parliament researchers, the Canadian branch of the CPA, and my Senate team for their support in making it possible to speak with you today. We know that IHL, International Humanitarian Law, is a set of rules and principles that aim for humanitarian reasons to limit the impact of armed conflict. And we know the two fundamental principles guiding IHL are as follows. Persons who are not or are no longer participating in hostilities must be protected. These include the sick and wounded, those caring for them, prisoners of war, and civilian populations. We know there are limits to what parties to an armed conflict can choose as methods and means of warfare. And sadly, tragically, we know that often these principles are not observed in practice. IHL is a part of public international law, which is a broad set of treaties, customary law, principles, and norms. While the framework traditionally regulated relationships between and among states only, it has evolved, logically, to cover a broad range of actors, including states and non-state armed groups that are parties to an armed conflict. IHL promotes and upholds a rules-based international legal system and contributes directly to enhancing the rule of law and good governance in our own countries and internationally, while maintaining international peace and security. As has been mentioned by my co-panelists, we know that IHL is composed of a broad set of treaties, their protocols, and international customary law. And that today, the 4 1949 Geneva Conventions and their additional protocols are considered the most important modern IHL treaties and have essentially replaced the 1864 Geneva Convention and the Hague Conventions. While this provides IHL with tremendous international influence, not all IHL treaties, including their additional protocols, have been signed or ratified. Moreover, in many jurisdictions, domestic legislation to give IHL full force is still lacking. As such, many states have yet to meet their international obligations under IHL, and this is where we, as parliamentarians, come in. But the adoption of legislation is only the first step in solidifying IHL and ensuring its efficacy. Other measures, such as training and resources for relevant departments and agencies, are required for IHL to be meaningfully implemented. As we've already heard from my co-panelists, customary international law refers to rules arising from established international practices or custom, rather than formal written conventions and treaties. Whereas treaties are only binding on those states that have ratified them, customary international law is considered to be binding on all states. In instances of conflict that involve one or more states that have not ratified all IHL treaties, these states are still bound by customary IHL. Non-state armed groups are also bound by certain rules of customary IHL. In fact, customary IHL is particularly important in internal wars, which now comprise the majority of armed conflicts, as the legal framework governing these conflicts is actually more robust under customary law than treaty law. Through IHL and international human rights law, which are distinct bodies of law, we can understand, nevertheless, that they are complementary. Both are concerned with the protection of the life, health, and dignity of individuals. One of the primary distinctions between the two bodies of law is that IHL applies in armed conflicts specifically, while IHRL applies at all times in peace and, at least in principle, during times of war. Another important difference is that IHRL is monitored by UN treaty bodies and related mechanisms to supervise implementation and contribute through both what are known as general and specific comments made by the independent experts elected by member states of the UN to serve on the treaty monitoring bodies. Each of the major human rights treaties, international human rights treaties, has a related expert treaty monitoring body. As an international human rights lawyer, I consider much of this jurisprudence generated by the independent experts on the treaty monitoring to be excellent in content. But we do need to bear in mind that the findings of the human rights treaty monitoring bodies, such as the Committee on the Elimination of All Forms of Discrimination Against Women, these are, in practical terms, influential, but they are not enforceable. And though IHL has several mechanisms for its implementation and enforcement, the ICRC has acknowledged that non-compliance with IHL remains an intractable problem. So, in many ways, what we're describing today are excellent frameworks with excellent content and with very spotty and hard to implement on the ground protections that actually benefit people and allow them to live their rights. I want to commend the CPA in partnership with the British Red Cross on producing the handbook that's been mentioned already and was posted in our chat to be able to look at it if you haven't already had a chance. It's International Humanitarian Law, a handbook for Commonwealth parliamentarians. And I find that it provides a number of ways parliamentarians can contribute to the development and implementation of IHL within our respective jurisdictions, including the introduction of legislation, oversight of the executive, budgetary considerations, leadership and advocacy, information, education, and support, implementing and supporting the enforcement of IHL. I want to share with you a few examples of ways in which the 4 years that I've been a parliamentarian, I have experienced among my colleagues in trying to advance and apply IHL and IHRL. Parliamentarians in Canada did not end their pressure to further entrench IHL into the Canadian legal framework with the passage of the Geneva Convention Act in Canada in 1985. Ensuring Canada continues to strive to meet its international obligations under IHL and IHRL is an ongoing process, and parliamentarians are crucial for maintaining this momentum. Some of the notable ways Canadian parliamentarians have continued to contribute to the development and implementation of IHL in Canada has been through our legislative process, including committee studies and motions in Parliament, sometimes in one house, the House of Commons, sometimes in the other house, the Senate, and sometimes with joint motions, where as a bicameral Parliament, we have come together. Legislation. The passage of legislation is one of the most fundamental responsibilities of us as parliamentarians, and a critical component for the successful development and implementation of IHL. It provides a number of opportunities for parliamentarians to help their countries meet their international obligations under IHL. To give IHL domestic force, legislation needs to be introduced and adopted by Parliament. As new legislation makes its way through the legislative process, we as parliamentarians have various openings to intervene and make meaningful contributions. For example, when a bill is first introduced in the legislative chamber, parliamentarians may draw attention to certain aspects of the legislation they view as beneficial or problematic. This simple exercise signals potential sticking points to the executive branch, but it also brings public attention to the legislation, thus educating the public on IHL. I have noticed that in terms of media attention and public awareness, one of the most effective ways in which parliamentarians can give voice is through the inclusion of civil society experts in our committee processes. The significance of public awareness should not be underestimated. For IHL to be effective, it must be understood by parliamentarians as well as by the public. Keeping the public apprised of IHL is also an opportunity to underscore its importance and to make statements supporting IHL, explaining IHL, and committing to the implementation and enforcement of those principles. Finally, parliamentarians may also introduce legislation themselves, particularly if they are dissatisfied with the proposed IHL legislation or dissatisfied with the pace at which the executive branch is taking to introduce legislation. For example, 2 days ago, the House of Commons in our bicameral parliament adopted, with only one abstention from our Global Affairs Minister, a motion declaring the treatment of Uyghurs in China as meeting the criteria to be named a genocide. Parliamentarians also have a chance to meaningfully contribute to relevant IHL legislation during committee study of the relevant bills. During the committee stage, parliamentarians may call on the executive branch to answer specific questions about the IHL-related bill, and can also invite expert witnesses, including academics and relevant stakeholders from civil society. An obvious example of this would be when the Red Cross is called, or the Red Crescent is called, as an expert witness to committee proceedings. Witnesses play a key role in informing parliamentarians and the public on the importance of IHL, and they offer advice from a perspective that many parliamentarians do not have. They're on the ground, they're on the front lines. Committee members can also use this stage of the legislative process to ensure appropriate mechanisms, procedures, and protocols are in place to enforce compliance with IHL once relevant legislation is brought into domestic law. Let us all remember as parliamentarians, a law is simply a set of words until we put in place the resources that make it possible to actually implement the law. And as I said earlier, it's the implementation of law that actually makes it possible for people to live their rights. We have established in Canada several all-party bicameral committees that include both members of Parliament and senators. For example, we have an all-party parliamentary committee on human trafficking and modern slavery. We have an all-party parliamentary committee on human rights. And that committee has addressed crises in Yemen and, of course, the Rohingya exodus from Myanmar. In the Parliament of Canada, committees may also conduct subject matter or thematic studies, and they are conducted by the committee and then reported back to our respective chambers. The objective of these studies is to review a topic by inviting relevant witnesses before the committee to provide evidence. These subject matter studies not only provide an opportunity to hold the government accountable on its international commitments, but also to gain the public's interest and raise awareness about the importance of IHL. When parliamentary committees conclude their studies, they usually table their findings in Parliament through a report that contains recommendations for the government or other regulated agencies, although there is no obligation to implement. These committee studies present another opportunity for parliamentarians to ensure the executive branch is meeting its IHL obligations. In 2018, for instance, the Standing Senate Committee on Human Rights tabled a report entitled Promoting Human Rights, Canada's Approach to its Export Sector. This focused on Canada's Export and Import Permits Act and paid particular attention to the sale of arms. In the report's recommendations, the committee called on the Government of Canada to enact stronger measures and mechanisms to ensure goods and technologies being exported from Canada are not contributing to serious violations of IHL. I will speak only for myself here when I say, as a Canadian parliamentarian, I remain gravely concerned about the sale of armored vehicles to Saudi Arabia worth billions of dollars that continue to be allowed by the Canadian government. The process of conducting subject matter studies may also have an impact on policy. Holding public hearings with witnesses can bring attention to an issue that might otherwise go unnoticed. In 2019, for example, the Subcommittee on International Human Rights of the House of Commons Standing Committee on Foreign Affairs and International Development held hearings on the humanitarian situation in Syria. At the conclusion, the subcommittee issued a news release calling on the states involved in the conflict to end violations of international humanitarian law. This was the center point of what the subcommittee was communicating publicly and to our government. The suffering of the Syrian people is beyond words, yet that should not keep the international community from speaking out. We must not lose sight of the humanitarian catastrophe in Syria. Canada must continue to strongly condemn the targeting of medical facilities, indiscriminate bombings, and all violations of international humanitarian law. That is a quote from the media conference introducing the study of the committee. Let's look for a moment at motions. And may I just check in terms of time, because
can you start to wind up, because we've only got about 20 minutes more for the whole event. Thank you, Senator.
Thank you very much. In 2016, we had a motion in the House of Commons bringing attention to the plight of the Yazidi people, especially the women and girls. And moved by the plight of the Yazidi people, the House of Commons unanimously adopted a motion that recognized that ISIS was committing genocide against the Yazidi people, acknowledged the suffering of women and girls, and called upon our government to provide asylum. This actually resulted in the relocation of many families, sadly, usually without their fathers, to many different parts of Canada. And in fact, where I am from, Manitoba, has the largest single concentration of Yazidi refugees who have been resettled in our city. With that, I will close and thank you very much for this opportunity to address this very important topic.
Look, Senator, thank you so much. That was wonderful. And if I might say, congratulations to Canada for resettling so many of the Yazidi refugees. And I can certainly say from my own previous experience when I was chairing the International Development Committee in the United Kingdom House of Commons, those inquiries that you describe can be so important in raising the profile of issues around international humanitarian law. And we certainly had them on Yemen, on Syria, and on the Rohingya crisis in Myanmar and Bangladesh. So thank you so much. Look, we've got 20 minutes and I'm really keen to hear some of the questions. We find it works best if people put the questions into the chat or the Q&A, and Canada is certainly winning the prize for presence at this event because I have two sets of questions from Canadian parliamentarians. So let me start with, I think it's Senator Salma Atolajan, who has asked a question which Senator McPhedran has touched upon, but I'll give all three panelists an opportunity to respond to. How can laws and policies be created by parliamentarians designed to encourage effective enforcement and implementation of IHL? And then our second question comes from Yasmin Ratanzi, who is the chair of the CPA region in Canada. And she asks, what happens when countries violate international law? And she gives international human rights law. She gives the examples of the use of chemical weapons on civilians or the use of child soldiers. These types of wars may be confined to a country but have international players. Are there any sanctions? How do we protect civilians? And how long does it take to get justice? So some really big questions that strike at the heart of what we're doing. She also goes on in a second question to refer to this term collateral damage that she says is so often used to describe civilian casualties, and that is itself creating a humanitarian crisis. So I'm going to come back to our panelists on those questions and invite them to respond. Don't feel you need to respond to every single aspect, but I will come in the same order that you'd spoken earlier. So Calisiana first. Thank you.
Thank you very much, and thank you for those questions, everyone. Yes, I mean, a range of really deep questions there, so I think they're very important. In relation to how can parliamentarians put in place effective laws, certainly there are a range of, I mean, Commonwealth countries, just to start with, have adopted, ratified, acceded to a number of international humanitarian law treaties. In fact, I just recently wrote a report with the British Red Cross for the meeting of senior law officials of Commonwealth ministries of justice, and the number of treaties in the last 2 years that Commonwealth countries have become a party to is staggering. Well over 20 ratifications from Commonwealth countries. But as has already been mentioned, that's really only the first step. Then it's the question of putting in place legislation. And so I would say that parliamentarians should keep an eye on those ratifications. I mean, they do already through Commonwealth parliamentary processes, but then say, right, once we've adopted those treaties, how can we actually practically put them into place? And in many cases, it's not just legislation. I mean, legislation is very important, particularly to criminalize certain aspects of those treaties. For example, if they've become a party to the Convention on Cluster Munitions, it's important to put in place a crime for the use, transfer, stockpiling, and so on of cluster munitions. But then it's very important to also monitor, to engage with the Ministry of Defence, for example. How are they putting in place the practical aspects of really enforcing such a treaty? So I think that parliamentarians have a good role to play, as has already been mentioned by the Senator, in terms of highlighting the issues of IHL that countries are already a party to, that are already accepting, and then using their influence with various ministries to either provide them with more resources. I thought that point was very well made, but also to disseminate, to really engage with those ministries to say, what are you actually doing in regards to this treaty that we've become a party to? And I think that becomes very important. Maybe in relation to the question of collateral damage, I think that's a very well made point as well, in terms of the fact that we call it collateral damage, we call the deaths of civilians collateral damage, does have a tendency to downplay the severity of the issues around civilian deaths in conflict. I mean, as Professor Garraway has said, there is this need to balance military necessity with humanity, and unfortunately in conflict, there will always be civilian casualties. But indeed, it's very important to try and limit them. And increasingly, we do find, I mean, obviously, we've seen some terrible attacks on civilians in recent times, but in many contexts, there have been measures that have been put in place to try and limit attacks on civilians. I mean, this is something that ICRC is following very closely in terms of our work on protection of civilians. But many militaries have now put in place special civilian casualty units to try and monitor where civilians are, to try and limit the attacks on them. And I think that, I mean, of course, lots more needs to be done. In fact, we're working at International Committee of the Red Cross, and a number of countries are working on limiting explosive weapons in populated areas, for example, to try and limit the use of explosive weapons where civilians might be located. So trying to put in place these sort of initiatives to limit the effects of armed conflict is constant, it's ongoing. But yes, certainly I think the point around the terminology is very correct, that sometimes we have a tendency to downplay attacks on civilians, and I think that that's an area where we should maybe be a little bit more upfront about the fact that civilians continue to be the main targets of attack at the moment in armed conflict.
Thank you very much indeed. Professor Garraway.
Thank you. We are dealing here with areas where three great branches of public international law come together: international humanitarian law, international human rights law, and international criminal law. And sometimes the edges are a little bit fuzzy, shall we say. I think one point I would make from the start: attacks on civilians are prohibited. Full stop, end of story. I hate the term collateral damage. And one of my concerns when we're looking at what I call the principle of proportionality is that it actually gets too much focus. And people therefore say, once you reach the stage where something is proportionate, then that's all you have to do. It isn't. We forget precautions in attack. And you've got to go on, and you're under an obligation to minimize civilian casualties and civilian damage. So even if it's proportionate, that's not enough. You've got to go further to try, if possible, to avoid them altogether. And I think that is often forgotten. Now, what can parliamentarians do? International humanitarian law I sometimes describe as a three-legged stool. One leg is clear. It must be clear because soldiers have to apply it. It has to be credible because commanders have to believe in it. And it has to be enforceable because otherwise it's not law at all. And it is the enforcement arm that has often been the weakest. But what we need to remember is that enforcement starts at home, like charity. And yes, you may have the International Criminal Court. You may have the International Criminal Tribunals from former Yugoslavia, Rwanda, Sierra Leone, etc., etc. But I ask all states, parties to the International Criminal Court, have they got domestic legislation in place so that they can do their bit to ease the burden on the International Criminal Court by prosecuting cases in front of their own courts? And it's a sad fact that not enough countries that are parties to the ICC statute have. Even those states that are not parties are under obligation under the Geneva Conventions to have universal jurisdiction over grave breaches. Now, again, a lot of states don't have that legislation in place. So the key thing is start looking at home. What can you do in your own country before looking at what people should be doing on the international stage? I hope that's of some help.
That's a great help. If you don't mind, Professor Garraway, before I come to Senator McPhedran on this question, I would love to hear your reflections on the situation in Yemen in the light of what you've just said, and in particular, the apparent change in policy by the new US administration and what you think that might mean in terms of the application of international humanitarian law in the Yemen conflict. Ideally in about 3 minutes, if that's okay.
Yemen is a tragedy, and nobody has clean hands. Nobody. And I include the whole international community here. Absolutely. Because it is an international problem. It's not just a problem for the parties themselves. Absolutely. All states have a responsibility to try and help out with Yemen by influence, and in particular, as we've made plain in our reports, the suffering of the Yemeni people is going to continue so long as the hostilities continue. And the hostilities will continue as long as weapons are made available to the parties. Regardless of the legality of weapon sales, the fact is those weapon sales are contributing to the suffering of the Yemeni people. There is no military solution here. It can only, in the end of the day, be a political one. And the sooner we get round the table and start talking, the better.
Thank you very much indeed. And Senator McPhedran, you rightly emphasised Yemen as well as Syria and the Rohingya. I'm interested in your thoughts on some of the question in particular from the Honourable Ratanzi about some of the practical ways that we might be able to deal with challenges around, for example, the use of child soldiers or the use of chemical weapons.
Thank you so much for directing the question. I want just to quickly acknowledge what a pleasure it is for me to have both Yasmin Ratanzi and Senator Salma Talajan as my colleagues, and we often work together. I'd like to answer that question by actually focusing on the whole notion of how do we as parliamentarians either lead on or contribute to implementation strategies and the allocation of resources. And to do this, I want to commend a former senator in Canada, General Romeo Dallaire, and the fact that in his time as a senator, he has an institute as well that always continued to operate, but as a senator, his interface with the members of the executive, with cabinet ministers, with other parliamentarians, even after he left, it led to the 2017 UN peacekeeping meeting of defense ministers that was hosted by Canada in November of 2017. And as a result of that, that's where the Vancouver Principles were released. And these focus on peacekeeping and the prevention of the recruitment and use of child soldiers. And as a result of that conference, that was one of the first things actually as a senator I did was attend that conference with retired Senator Dallaire. And they set out 17 principles that focus on this prevention and recruitment. But let's fast forward to 2019 because they didn't stop there. And in a 2-year highly collaborative process, 54 countries signed the Vancouver Declaration on those principles in 2017. And by 2019, there was a very detailed guidance document on how countries can actually implement policies and programs that relate to preventing the recruitment and use of child soldiers. And of course, this ties in directly with the suite of Security Council resolutions that focus on children affected by armed conflict. And so for parliamentarians, what we have is not only a legislative framework, an international legislative framework, but we have the practical ways in which in our own countries, of those 54 countries, many of which are Commonwealth members, we can be looking at the implementation and using all of those methodologies that I mentioned, committee studies, questions in the House, etc., on the actual implementation of the principles.
Thank you very much indeed. Look, we have just under 10 minutes. So we have another question that has come in, and then I'd like to add a question of my own as well, and we'll finish with these answers. So feel free to use the answers to these two questions to make any final comments. The first is from Riaz Fatiana, who asks for your opinion on suffering of the Kashmiri people. So any comments you'd like to make about the situation in Kashmir? And I was curious if there were opinions on the court case in Germany this week, where a case was brought against someone involved in the Assad regime in Syria, and any comments specifically on that, but perhaps more broadly on the use of universal jurisdiction in courts as a mechanism for dealing with alleged violations of international humanitarian law or other war crimes. And we've got 6 minutes and there's 3 of you, so ideally 2 minutes each to answer about Kashmir and about universal jurisdiction. And I'll stick with the same order. So Kalisiana first, please.
Thank you. In relation to ICRC's confidentiality, I won't talk about Kashmir as such, except to mention that ICRC is has operations there. In relation to the Germany case, I think it's very interesting. I was quite thrilled to see them taking on universal jurisdiction, applying it in these particular circumstances. And certainly from our perspective, universal jurisdiction is very important to be able to limit impunity for serious violations of international humanitarian law, so that to act as a deterrent in many cases to stop people thinking that they can just get away with violations. I mean, practically, universal jurisdiction is very challenging. I mean, it really does take a country. Well, Canada is also engaged a lot on prosecutions for people in Rwanda and other places. But yeah, it does take a country like Germany, Canada to step up and really use universal jurisdiction to best effect, because it does involve quite a lot of resources. But no, it's very encouraging to see such cases.
Thank you very much indeed. Professor Garraway.
Thank you. I too will have to avoid reference to the Kashmiri problem, largely because of my own ancestry. My father was Indian Army. His regiment is now the premier regiment of the Pakistan Army, but other battalions of it are part of the Indian Army.
Wow.
It is a tragedy, the situation in Kashmir, and I would love to see it concluded before too long. On the court case in Germany, yes, universal jurisdiction is incredibly difficult. It involves evidential difficulties, it involves cost, it involves all kinds of problems, but it is essential. And it can only be done, I would suggest, if there is that domestic legislation in place. And too few countries have any legislation in place, even to deal with fundamental war crimes such as grave breaches. And I would urge all parliamentarians to look at their own domestic legislation and see, if a war criminal came to your country, what could you do about it?
Brilliant. Thank you very much indeed. I think that's a powerful and well put challenge to parliaments and parliamentarians across the Commonwealth and indeed beyond. If I can come finally, last but by no means least, to Senator McPhedran for any response to those questions and your final comments. Thank you, Senator.
Well, I think this is an ideal opportunity for me to give another shout out to civil society leadership and civil society expertise, and the fact that as parliamentarians, we should be able to build good communication with civil society leaders that are doing careful research and often taking a great deal of risk in order to gather information. For example, the BBC report on the Rohingya in China that's resulted in the expulsion of the BBC from China. So in terms of Kashmir, I think right now we're in a situation where the best information is available to us from civil society actors, Human Rights Watch being one of them. And the way in which there's a documentation of the Indian government's decisions around restrictions, interesting decision by their Supreme Court, I believe it was the Supreme Court, that said you can't shut down all internet in Kashmir. That's a right infraction. And so I think in answering the question, I would just have to say that as parliamentarians, we are constantly navigating between sources of information, and it's very important, I believe, that we not limit our sources of information only to government sources, that we reach beyond that. Thank you.
Absolutely. Well, look, thank you so much indeed, Senator. If I can bring apologies, unfortunately, Senator Rubina Khalid from Pakistan, who was due to be our 4th panelist, wasn't able to join us and we missed her, but I think we've had an amazing hour and a half. I mean, I feel I'm sitting here with lots of questions I'd like to ask in addition to the ones that we've covered, but we are very, very sadly out of time. But if I might finish with 2 comments. The first is to echo what Senator McPhedran said at the end about the importance of information on the ground from civil society, from local independent journalists, and not just relying on official sources. And certainly in the work that I've done previously on Yemen, that was very much what we felt. Yes, we listened to the official sources, but we wanted that information on the ground as well. And finally, to say, I think this is in many ways a conversation that needs to carry on, not right now, but we will be updating the CPA British Red Cross handbook. That, I think, will provide an opportunity for further discussion. And I think all 3 of our excellent panelists have set out the kind of issues that parliaments and parliamentarians need to address. And I just want to say from the CPA, we will facilitate that, we will be part of that, and we look forward to continuing to work with all of you as we take this forward. But if I can ask the audience to join me in a virtual clap to our 3 excellent panelists for their contributions today. Thank you to everyone who joined us, and have a good rest of the day. Thank you very much.